to call it up for a vote, too, please.
Councilwoman Madison, will you please place Council Bill 1003 on the floor for adoption?
Could you give me a page number on that?
9.
That's page 9. Okay. There it is. Got it.
Page 9.
I would like to place Council Bill 1003 as amended on the floor for final publication and for a vote.
It's for final adoption, just to be clear.
Final adoption and a vote.
Thank you. It's been moved and seconded. Comments from members of council? Councilman Linkhart.
Thank you, Mr. President. I'll be brief. We debated this at length last week. After our debate last week, I went out in the hallway and talked to a gentleman who had invested $800,000 into a cultivation center that he will now have to close because he didn't meet some of the deadlines in the bill. I visited another cultivation center in a very industrial area next to the Pepsi Bottling Company last week, and they had invested $300,000 and will probably not invest $200,000 more because of the uncertainty caused by this bill. The bill basically throws 52 businesses under the bus by creating regulatory uncertainty. It leaves centers stranded. It leaves patients stranded. There will be millions of dollars in lost investment and jobs lost during the time when we can least afford it. So I'll be opposing the bill tonight.
Thank you. Other comments from members of council? I can see you poking away there. I don't know why it's not showing up. Madam Secretary?
Wait, hold it. I want to speak, and
I know you do.
It's not working.
The one on top.
There you go. Councilman Brown.
Thank you, Mr. President. I have some questions for Penny May. I see her in the audience. Penny, as you know, we have been operating as we put this bill together as if everything is going to hit on July 1st of this year. And now we hear, based on what is happening at the Capitol, that it seems to be unraveling in terms of a date. And now they've actually inserted into House Bill 1043, I think that's the correct number, that this bill will not go into effect until the state bill, until July 1 of next year.
That's correct.
That's correct. There are a couple of questions, and I'd like to hear a comment from David as well. Why are we rushing? It's a logical question. If this is going to be, another year in 3 or 4 months. But more importantly, what happens in the interim if this bill is passed tonight?
Well, I'll do my best to give my answer, and then I'll refer to David Broadwell. As of today, the July 1st, 2011 date is still valid. So we would move forward with reviewing the applications from the state and to begin issuing licenses. As far as I understand it, 1043 has not been adopted yet. Right. So I don't know how that will come into play.
Right. And let's be sure, everyone, no one is one of 3 members up here who has worked on the Hill. No one can predict what's going to happen. Let's just get that right out. Hell, they might change it to 2013. But right now, it reads 2012. David, do you want to bring us up to date on that, please?
Thank you. David Broadwell, Assistant City Attorney. As Penny just said, we have to go with the law as it is right now, and that's kind of the assumption we've been making the last several months as we debated this ordinance. But I can tell Council, for better or worse, depending upon this detail of the new House Bill 1043, and other details of the bill, depending on how it finally comes out in the end, we will probably have to revisit your licensing ordinance to reconcile parts of this ordinance with the state law as it continues to evolve. Certainly on the issue that Councilman Brown has raised, if they indeed push out to July 1, 2012, the effective date of the new licensing requirement under the new dual scheme under the state law, then we absolutely are going to have to make some changes to our law to clarify how we're going to be treating medical marijuana businesses that are on the ground between now and July of next year. We just have some dates that don't work right now in terms of how our laws are written that we'll have to work with. But as far as 1043 is concerned, it's only come out of one committee so far, only the first committee in the first House, and it's sitting in another House committee right now, as I recall. So it definitely has a ways to go. I'm hopeful this year that the legislature won't wait until the last day of the session to finally pass it. And that's what happened last year, and I hope it makes it over to the Senate soon, and the Senate can go ahead and do what they're going to do, and we can see what that is. It was certainly, if, again, under current law, we're looking at July 1 of 11 as being the target date for implementation. If it's going to be anything different, the community, folks in the industry want to know about it. We have folks obviously on both sides of that issue, both people currently in business and people who would like to go into business in the future and come in and apply for a license in the future. If we're still going to be in this limbo period for another year, it's hugely important to both of those groups, both the people on the ground and to people who may want to enter in the future. So we'll continue to report to Council as changes occur. If the bill's passed tonight, it will not be the final word on the subject. We're going to have more discussions in the next couple of months.
And if I may, Mr. President, another question for Penny. And Penny, we were told we had to do this because we all thought it was going to be July 1 of this year. And would you explain that relationship? Who is going to, we have to get state forms from the state. Is that accurate?
The state will provide all the forms. It's my understanding that all the applications that were submitted last year will be sent to us for review and approval so that we can issue and the state can issue license under the dual licensing schedule.
So you're not printing anything. The state is going to do that.
Yeah.
And so you think perhaps maybe they saw how much work is involved and knowing that they couldn't make the deadline. Because printing these forms is a real task, as we've all learned up here.
They did prepare forms last year for businesses to apply to meet the July 1, 8-1, and 9-1 dates.
But everything we do is tied to state action.
Yes.
Okay. I'll have other comments later. I'm sure others want to talk. Thank you.
Thank you, Councilman Brown. Councilwoman Sandoval.
Thank you, Mr. President. So along the same lines of questioning for our city attorney, David Broadwell, are there parts of this bill that require us to address more immediately? I know that this bill creates the 3 classes of license, which we didn't have before, the medical marijuana center license, the optional premises cultivation license, and the medical marijuana infused manufacturer's license. So are those things that we immediately need to address? Or what other parts of the bill need to be immediately addressed?
Well, again, back to this issue of whether or not the state law is going to change. Well, assuming that it stays the same, if that's possible, and folks, in order to be legal after July 1 of 11, have to have in hand their licenses, then we need to say affirmatively as a body that we're entertaining all 3 classes of licenses in Denver and create procedures and requirements for the 3 classes of licenses. So that's been the main thrust of this bill from the beginning, is to affirmatively opt in and say we're doing all 3 classes of licenses in Denver. And as you all well know, the main debate has been, and where in Denver you can qualify for each of those 3 classes of licenses. But as we discussed last week, there really is not a lot more to the bill in terms of adding a lot of additional requirements or addressing any secondary issues about how these types of businesses are supposed to operate. Is fundamentally making the classes of licenses available in Denver as soon as the state gives us the forms to begin processing, and to say where the licensing can occur. So that's what it is at this point. We'll see. We'll continue to monitor changes at the state level.
Thank you, Councilwoman Sandoval. Councilman Linkhart.
Thank you, Mr. President. Now I have a question, David. It seems like we're sort of at odds here. At your suggestion, this bill presumes that the legislative bill being considered this year will take away the privacy requirement. So we're anticipating a change there, but we're not anticipating a change that's already been made in the bill as well, which is the date change. So I guess I'm wondering, if the date stays changed to 2012, does that mean that the cultivation centers on the ground now would not get their permit until a year from July, and then the 2 years would kick in after that? So we'd have to change that 2013 date and the 2011 date to 1 year beyond, so they actually have 3 years to exist?
First of all, I think there were a couple of questions there. Let me handle the second one first. We don't mention 2013 in the bill. We talk about how at the end of a 2-year licensing cycle, cultivators and nonconforming locations are subjected to a public hearing. So if their actual initial licensing is pushed out some, same principle, then 2 years from then they would have to have a hearing to get a renewal. But you're raising a really good point on the first part of your question. You're right. We've freely admitted that if the confidentiality provision stays for the location of cultivators, notwithstanding what's in 1043 right now, let's say that stays, then we're going to have to revisit the whole viability of having hearings on cultivation licenses. But that's not a real issue on the ground until sometime a couple of years in the future, when we'll have time to reassess whether or not we have to deal with that reality. But on the front end, in terms of initial licensing by July 1 of 11, this is what the urgency has been to get some sort of ordinance passed, because we have front-end urgency on some of those issues. But, Councilman, hold that thought. You're exactly right that if we're wrong about the confidentiality issue, if that stays a part of state law, we're going to have a come back and have a conversation about that again, about the viability of having hearings.
Thanks.
Thank you, Councilman Linkhart. Councilman Brown.
Thank you, Mr. President. David, if this bill passes tonight, will it put anybody out of business until the state acts?
The answer to that is no. There's a certain status quo under the law that exists under 1284 and under existing city laws between now and July 1 of 11. Again, the need to have licenses under this ordinances, licenses under state law, doesn't kick in any earlier than July 1 of 11. Okay, so we will continue to be in this interim period tomorrow, the next day, up until July 1 of 11, where the people's legal viability, their ability to be on the ground today and continuing until July, is dependent upon whether or not they met certain statutory deadlines under 1284 as of last year. Those people will be able to continue if they meet the requirements of 1284, if they've got their plant husbandry permits or their manufactured food licensing licenses and so forth. They can stay legal. This will not change anything on the ground in terms of people's legal status today or tomorrow. The key question is what's going to happen after July 1. Who will qualify for a license at that point?
In July 1 of this year or next year?
July 1 of 11 is the current law until it changes.
I mean, the state is in the catbird seat in terms of the date.
That's right. They're the ones that created the July 1 target date to begin with. They can change it. I mean, this whole phase-in that was created in 1284 was their doing. The whole creation of the vertical integration model and the classes of licenses, that was their doing. They created this interesting transition period, that was their doing, where people had to, topsy-turvy, they had to apply for their state license first, last August, before coming to their local licensing authority. That was the basic genius of House Bill 1284 that we're now contending with this year. But just as they created it, they can amend it, and And we're seeing that happen. I mean, I can guarantee you there's going to be some changes. We just don't know what they're going to be at this point as we sit here at the in the latter half of February.
Thank you, Mr. President.
Thank you, Councilman Brown. Councilman Linkhart, back
I
to you.
think I was clearer when I came in than I am now. And David, if the bill passes, there are businesses that won't be able to continue because unless I'm wrong, you have to meet those dates in last year, 7/1, 8/1, I believe it's 9/1 or 11/1, and you have to have started cultivating by January 1st. If you didn't start cultivating by January 1st or didn't meet those other deadlines, you can't get a cultivation license. Is that right? Or can you do it for the next?
The licenses that people will be applying for under this ordinance will have a start date no sooner than July 1 of 11. So if that date remains the same, people will come in and start applying locally for licenses under this ordinance to go with their state applications for a license that will have a beginning date, July 1 of 11, the way the state law is currently written. That doesn't define at all who can continue to be legal prior to July 1 of 11. That's addressed completely elsewhere in pre-existing state and city laws right now. Who gets to be legal now before we get to July?
Okay, thanks.
Thank you, Councilman Linkhart. Councilwoman Robb.
Okay, so in a worst case is in the eye of the beholder again, but if the state extends the licensing to July of 2012 on the last day of the session, which is the last day they could do it, so it would be, in my opinion, worst case, latest notice that we would get in order to legislate, then we would have approximately a month to adjust the dates in our ordinance to conform.
That's the question?
That's the question. I'm asking for confirmation. Is that correct?
A month and a half, or 7 weeks, something like that.
Okay, so we would have time to adjust it so that people who may have come in and applied for applications, they're okay. They don't get their license. They can go on operating, and people who are starting up and were a little late may get to come in. Would that be correct?
It depends on the way the state law is written. One of the features of 1043 as it's written right now, it talks about this principle that local licensing authorities won't begin to act on new license applications until we process the stack from last summer. In other words, we'll be under an obligation to first process all those businesses who met deadlines last year before we start accepting new licenses from people who weren't already in the queue. And so who will be able to do what, after 1043 is adopted will depend upon exactly what the details of that bill say in its final form.
Okay. Thank you, Councilwoman Robb. Any other? Councilman Brown. Back to you.
Thank you, Mr. President. As you recall, a week ago yesterday, we had a discussion debating the 2-year versus the 4-year issue. And we heard some new information about a donation of parkland and the implication that that could have on that donation. And I was wondering if Councilman Linkhart was going to introduce that amendment again so we could resume that discussion, because I think that's a critical issue to people in this room tonight. So, Councilman Linkhart, are you prepared to introduce that?
Councilman Linkhart?
It's fine. Thank you, Councilman Brown. I was not going to introduce it unless we had 7 votes to pass it. So, no, I was not able to change any minds up here from last week.
Sorry to hear that.
You still have the floor, Councilman Brown, if you'd like it.
No, I was hoping for more discussion on the bill. And I don't see any names.
I could go back to Councilman Linkhart.
I think we dominated this whole discussion anyway.
Okay. Thank you, Councilman Brown.
Thank you.
Going once, going twice. Madam Secretary, roll call.
Brown.
No.
Fox.
Aye.
Hancock.
Aye.
Johnson.
Aye.
Lehman.
Aye.
Linkart.
No.
Lopez.
Aye.
Madison.
Aye.
Montero.
Aye.
Robb.
Aye.
Sandoval. Aye. Boygan.
Aye.
Mr. President.
Aye. Councilwoman Fotz, your vote is still hanging.
I'm sorry.
That's okay. You can close the voting, announce the results.
11 ayes, 2 nays.
11 ayes. Council Bill 1003 has been adopted.